He is a Christian, a member of the university choir and Christian Union. Having introduced the accused person, Your Honor, I'll address you to what the prosecution purports to be compelling reasons. And Your Honor, as I address you, I want to go on record that our guiding document is the Constitution, and that the cardinal consideration when issues of bond and bail are being canvassed is whether the accused person will be able to attend court or not. That is the primary cardinal consideration. The rest are secondary and tertiary considerations. They have not denied that he's a student. What they have said is that his only crime, he ran away to his mother's house. Did they expect a 19-year-old to have a home? He is available. He will attend court dutifully as and when he is required. Your Honor, then the prosecution goes on a trajectory of wailing louder than the bereaved and saying that the accused will be insecure. Your Honor, it is settled law. And I'll quote the dictum of Ouko J, as he then was, in Nicholas Kipsigei Ngetich and two others versus the Republic. While the prosecution raised such issues, and while frowning at the issues, the court said, it is the duty of the state in terms of Article 29C of the Constitution to ensure the safety of all citizens. He goes further and says, it cannot be in the mouth of a state official, like the prosecution here today, charged with the duty to provide security, to allege that a citizen, for whatever reasons, can be insecure. What they are inviting you, Your Honor, is that as you release Ian, the state is asking you to compel the police to ensure he's safe and secure, to remind them of their cardinal duty. Your Honor, the second issue is the issue of interference of witnesses. We are at pains to submit how a 19-year-old student will interfere with a 57-year-old police officer and the witnesses lined up by the police force with unlimited state machinery, including tools of violence. In any event, in Republic versus Dwight Sagari and others, High Court case number 61 of 2012, the High Court has this to say: for the prosecution to succeed on the line of witness interference, it must bring before court cogent evidence of either real or perceived interference. Your Honor, whereas counsel are supposed to be well deep into the law, books of law and the Kenya law reports, here is a prosecution that has taken a bit of time on social media and brings you a clip of one Mike Sonko. We do not want to discuss Mike Sonko in this court, but it is embarrassing to the state that the only material placed before you is an alleged conversation of Mike Buvi Sonko with unknown Kenyans without demonstrating their relationship with the accused person. And that is why we strongly believe that it is part of the script by the National Police Service, aided by the prosecution, to concoct videos to come and convene this court that there is witness interference. Refuse that invitation, Your Honor. Your Honor, the prosecution has said that this offense is so serious, and my learned brother Omari has equally dramatized it in a very good manner by saying that when the accused person allegedly attacked the police officer, that he was attacking the crowd, that he had his cape on, that the uniform was blue, that he was beating Kenya. Your Honor, the question that we should ask is this: when a police officer take bribes, and there have been convictions of taking bribes, do they take bribes on behalf of the nation and the people of Kenya? When the police officer kills Willie Kimani, are they killing Willie Kimani on behalf of the people of Kenya? Your Honor, the same way the police commit crimes in their personal capacity, when it is alleged that they are beaten, it is individual police officers who are beaten and not the state. Your Honor, we submitted yesterday that the seriousness of the offense cannot be relied on by the state to deny bond. And we gave you the authorities. Would not wish to say more regarding those authorities. Very lastly, Your Honor, the state has demonstrated by way of submissions that even if you released the accused person, the police force will not be willing to protect him. We wish to go on record as advocates of the accused person that what is alleged to have happened was a tragic comedy. It's called a tragicomedy in literature. And the accused person in that play, if they're relying on social media, is the tragic hero for refusing to pay a bribe. He has been dragged to court and is here with us. What will happen if you hand the accused person to the police officers who are in this courtroom in unprecedented numbers? Not even charges of terrorism have attracted such a huge chunk of police officers. What will happen to this accused person? Your Honor, this court has the cardinal primary responsibility of not just ensuring the liberty of the accused person, but also ensuring his security, whether he is in prison or out of prison. And what Odunga said that I must pen off with, Odunga said the decision that I have given of Nicholas Kipsigei, that it is absurd for the state to imagine that the only safe place for an accused person is prison. That was Odunga J, as he then was, lamenting at the state's submission that prison is safer than home. I rest my case, Your Honor.
Thank you. Mr. MPESA, any detail?
Yes, Your Honor. On behalf of the state,
Whose application is it?
I have a rejoinder to the submissions made on behalf of the accused person. I'll start with asking the court to strike off the record submissions of facts coming from the bar. It is very embarrassing for Your Honor to be invited severally to caution counsels not to make submissions about facts.
He's a corporal. If they really valued his services to this country, they ought to have promoted him to a level of sergeant, at least, if they so much care about him. That persuasion is for you to read the emotion.
Hardly my senior, though he has never been promoted to senior counsel, is still attacking the victim. I'm appealing the victim to be protected by senior counsel.
But you brought the victim to court.
I'm only looking at promotional issues, career progression. I have no business in this matter. Neither is it an employment and labor relations court.
Your Honor, They brought the issue of the age. It is in the affidavit, and they don't want us to go there. But we can forgive Mr. Omari for that oversight. Your Honor, you have been persuaded that this matter was in Fuko. It was in this radio station. It was in that television station by my learned sister, Miss Njoroge, Miss Karaoke. Your Honor, the reason why the prosecution is very, very persuasive, or they would really, with 3 traffic counts of causing obstruction, carrying excessive passengers, and disobeying verbal directives. Your sister magistrate, Madam Nanzushi, was graciously to grant us a cash bail of 60,000 shillings. They did not oppose it there. The reason why they are opposing it here, it's because of fitna. And fitna is malice, the particulars of which you have given. Sisi tumesoma Kiswahili na ibara ya 8 inasema Kiswahili ni lugha ya taifa na ni lugha ya ofisi. Kwa hivyo tunasema ni fitna, tumepatiana sababu zenye tunajua ni fitna. Kwa sababu kama hawakupinga dhamana kule, sijui ni kwa nini wanaipinga hapa. Your Honor, throughout the submissions of 4 state agencies, including Omari, because he called himself state agencies, they all relied on Section 60 of the Evidence Act, forgetting that that section does not only belong to the sovereign, as they call themselves, forgetting again that the sovereign belongs to the people, not even to the state agencies themselves. That is Article 2(1) of the Constitution. Your Honor, you have been persuaded by Mr. Ashoka that a video or something was posted by Mr. Sonko. We do not know the relationship between Mr. Ashoka and Mr. Sonko. And maybe Mr. Ashoka and Mr. Sonko are in connivance.
Objection.
That's judicial notice.
Objection, Your Honor.
Judicial notice. For Mr. Sonko to post things on the social media, for Mr. Ashoka to come and rely on them here
Your
and
Honor,
say
Mr. Lempa
that
is a
these
very
things.
senior advocate. He should know the rules of the court. Once a counsel rises on his feet, you sit down. Your Honor, I do not wish to be dragged into this case as a party. I only brought it to the attention of the court that there are social media postings being done which show that there is interferences of witnesses. And I asked the court to take judicial notice of that. I have no, in fact, I'll not even bother to respond to about Mr. Sonko.
Yes, on judicial notice, Your Honor, we have the charge sheet. It's very clear. All the witnesses therein are police officers. Mr. Ashoka did not lay any basis that Ian Njoroge is likely to interfere with police officers. In fact, it is them who are likely to interfere with his health, as it has been demonstrated. So that when you are constructing Section 60 of the Evidence Act, Mr. Ashoka did not lay any basis that that particular posting by Mr. Sonko was posted by agents of the accused person. That's the point I'm driving. And because it is judicial notice and therefore speculative, we can speculate either way, that it has been made by the prosecution, and as Mr. Ashoka was claiming, was posted by ourselves, which we are denying that we have nothing to do with Mr. Sonko in these proceedings. So therefore, in conclusion, the prosecution and the National Police Service are the aggressors who are weeping louder than the bereaved. In those few remarks, Your Honor, there are no compelling reasons whatsoever to deny an accused person, regardless of the person who was attacked. Article 24 is very, very clear that the limitation should not derogate from the core content of the right, and the right here is to be granted bail. So therefore, we persuade you, tafadhali, Mheshimiwa, Mwachilie kijana huyu kwa dhamana. Hakuna sababu zozote zimetolewa. The seriousness of the offense, we have only 2 counts in this particular charge sheet: grievous bodily harm and resisting arrest. Hiyo ingine ni fitna, as we have demonstrated here.
Your Honor, matters of fact, my learned friend is a very senior advocate. He knows the procedures of laying evidence before court. It's through an affidavit, or the accused person should take the stand and make those averments under oath. They should not be coming from the bar, Your Honor.
Mkuki kwa nguruwe mtamu kwa binadamu. Waswahili wanasema kwamba ni mchungu. He made similar submissions. I'm only giving the account of what transpired to indicate to you that the accused person before you is not a flight risk. He confirms to me they went had lunch with his grandmother and his family at about 1 a.m. At 6 p.m. they went back to the house. At 8:30 p.m. the police
an opportunity to cross-examine counsel. Because those are matters of fact.
Well, I'll proceed, but the court has taken note of the account that he was therein after arrested at 8:30 p.m. while still at his mother's house. That confirms to Your Honor that the accused person before you is not a flight risk. You've been invited to look at the status of the victim, the alleged victim, his age, his time, period of service in the police service.